South African business magnate Patrice Motsepe embroiled in multi-billion-rand Tanzanian lawsuit. South African billionaire Patrice Motsepe is locked in a legal dispute in Tanzania with a staggering R3.44 billion $195 million at stake. The case, prominently positioned in Tanzania's commercial court dockets, resumed this Monday, bringing into focus the intricate legalities governing international business and resource exploitation in Africa. The plaintiff, Tanzanian mining entity Pula Group, has pointed the finger at Motsepe and a cadre of related corporations, including African Rainbow Minerals, AREP, African Rainbow Capital, and Arch Emerging Markets. Central to the contention is an alleged breach of a non-compete contract pegged to investments in Australia's Evolution Energy Minerals. This company's territory sits adjacent to Pula's graphite project, a factor potentially aggravating competitive tensions. Charles Stith, Pula Group chairman and the former U.S. ambassador to Tanzania, argues that the lawsuit's quantum was meticulously fired upon a third-party valuation. This accounting aimed to quantify the financial repercussions of Pula's purported competitive disadvantage, induced by what Stith deems an infraction of a confidentiality and non-compete agreement with Motsepe's business affiliates. In defense, Motsepe's consortium has dismissed the accusations as baseless, denying any contravention of the legal accord initially struck. According to an ARM spokesperson, the group weighed the prospects of diversifying into previously unmined minerals and accordingly entered an understanding with Pula, only to retract their investment interest later. Later, a decision communicated to Pula in due process. As the legal ballet continues, Pula insists there was a clear-cut 2-year non-compete contract in place, alleging the discussions and subsequent transaction with the Australian concern occurred during this restricted window. Stith's remarks resonate with broader concerns about the competitive disparities in Tanzania's and Africa's wider mining industry, often dominated by Australian and Canadian firms. The case not only seeks individual redress, but also aspires to craft a legal bastion for local mining initiatives pitted against global giants. Previous attempts by Pula to propel the case hit snags, with counterclaims from Motsepe's group on procedural faults, including improper service and questions over the Tanzanian court's jurisdiction. ARM's occasional no-show in court rounds off the list of pre-trial tussles. With the eyes of the mining world watching, the outcome of this case could reverberate beyond Tanzania's borders, potentially molding the legal landscape for corporate conduct and contractual obligations in the continent's resource sectors. Thank you for choosing Satori News.